I'm Drew Stevenson. This is for my administrative law class. And this video is about what we call agency guidance documents. We have a number of cases in our unit on agency rulemaking that are about these guidance documents that the agency claims fall under an exception in the Administrative Procedure Act. So we'll take a look at what's going on with this rule and these exceptions. Let's dive in. We have some exceptions to the notice and comment rulemaking under 553. The first category of exceptions covers, quote, interpretive rules, general statements of policy, or rules of agency organization, procedure, or practice. The second category, which is under 553B, little b, and then big B section, applies when the agency has, for good cause, finds that the notice and public procedure or public comment procedures are impracticable, unnecessary, or contrary to the public interest. This is typically going to be function as an emergency exception when you have some sort of crisis that the agency has to respond to immediately. So what's a policy statement? Well, in the words of the Attorney General's Manual on the Administrative Procedure Act, these merely, quote, advise the public prospectively of the manner in which the agency proposes to exercise a discretionary power. In other words, these usually announce which violations the agency prioritizes for investigations or enforcement, or which are low priority, or may even be safe harbors. They may announce that we don't plan to bring an enforcement action if you are below a certain threshold of non-compliance. Following in this vein, courts say that if the supposed policy statement ends up constricting discretion so much on the agency officials as to become binding, then it's not really a policy statement, but instead is a legislative rule. A true policy statement needs to be non-binding. So what's an interpretive rule? An interpretive rule is an agency announcement, it's often published, that purports merely to clarify or explain existing laws or regulations without creating new legal obligations. Agencies, by doing this, inform the public and especially the regulated industry about how they currently interpret and apply the statutes and regulations that they administer. Now, neither interpretive rules nor general statements of policy have the force of law. They are not themselves enforceable, and they are typically issued without the formal notice and comment process required for legislative rules, or at least what courts have come to call legislative rules. Interpretive rules and general statements of policy come up in a lot of court cases and court opinions, including ones that go up on appeal and that we will study in our unit. This is partly because agencies will sometimes try to avoid having to do notice and comment rulemaking, or worse, if this is a situation where their enabling statute requires them to do formal rulemaking, they will definitely try to avoid doing that. And so what they may do is characterize a policy announcement or a directive as a general statement of policy or an interpretive rule. These may just be called memoranda to the regulated industry or something like that. The titles can vary, but in the case, we're going to have a question about whether something is a general statement of policy or an interpretive rule. So why do the agencies do this? Remember that Section 553, again, has these exceptions and says that it doesn't apply, the notice and comment doesn't apply to interpretive rules and general statements of policy. So if they are running out of time with, because let's say there's an election coming up or a budget war in Congress or something like that, and they don't want to go through the whole public comment process, publishing a proposed rule, allowing public comment and waiting, then they may try to frame what they're doing as one of these other things instead. On the other hand, characterizing these documents, so let's say an announcement of a general statement of policy or an interpretive rule, as such, can affect whether judicial review is available at all, whether you can challenge what the agency just said in court, and it can affect what type of scrutiny or deference the court applies or how they analyze it. In other words, the agency is going to have a stronger argument that they haven't even done anything yet that's reviewable by a court, that there's no final agency action, and so on. It's a little different than when the agency promulgates a regulation and you know that if you don't comply, you are now in violation of a regulation. Now, in terms of when we get into court and we have these challenges, there's no real difference. It doesn't really matter if it's a general statement of policy or an interpretive rule. The questions the courts are going to ask are going to be the same, which is essentially, does this have the force of law? Is the agency trying to do something that functions like a legal rule or a legal requirement? Or is it really just an announcement of priorities? And so I'm going to give an example. Let's say that the agency says, we're kind of understaffed, and so we don't have the personnel to go after every single violation, technical violation or minor violation. So we're going to prioritize the most serious violators under our regulatory purview, and we're going to define serious violators with this threshold. So if you're above this threshold, you are likely to be the target of an enforcement action. If you're below that threshold, then we're probably going to leave you alone. This is a very common scenario for the agency to announce this. It sort of sounds like a safe harbor provision, right? As long as you're doing certain things or you meet a certain bare minimum standard, that you can kind of count on being left alone and not being the target of an enforcement action. And I hope you can see why someone may say that sounds like that's the rule, right? That's the line where if I go above that, I could face liability. And if I stay just below that line, I won't. But the agency may say, no. Technically, we could go after everyone, but we realistically can't because we only have so many people on our staff and our budget is finite. And so we're going to give more priority to violators in this type of category. So sometimes it seems like a semantic difference, but it can really have an impact on what's going to happen when we seek judicial review. And the same is true for an interpretive rule, right? You could have a statute that's 50 years old, and you have a new administration come in, and someone from the agency decides, okay, we need to address this growing social problem or this public health crisis or something like that. So they look at the statute, and there's some ambiguous language that reasonable minds could take different ways. And so they announce, we now interpret the statute to say that such and such is a violation of the statute, even though for years they've been ignoring that conduct, or maybe even had told people in the industry that they didn't think that counted as a violation. And now they're announcing it is a violation, but they're saying, we're not really promulgating a rule. We're just saying that this violates the statute. Let's see. Now, I do want to say the agencies also publish rules of internal organization and who reports to whom and employee manuals and things like that kind of guide the day-to-day work of the employees at the agencies about how they process their cases, how they open a file and eventually close out a case and so forth, or close out a project, and when they have to write a report about what they do and so forth. So they don't have to publish those for the outside world because it really only affects the people within the agency. But keep in mind, they do guide the day-to-day work and decision processes of a lot of the agency personnel, and they're not classified or top secret. You can get your hands on them if you're litigating against an agency and you want to understand more about how they made their decisions in your client's case or your client's matter. There's also an exception that we call the good cause exception for skipping the notice and comment period for the agency. In practice, this functions as sort of an emergency exception where there's some sort of national crisis or public health crisis that an agency has to respond to immediately, and there's no time to allow a public comment period and so forth. So they're just going to announce a new rule. and so on. If they do this, they have to state what the good cause is for not going through notice and comment rulemaking. We're not going to have cases about this in my course. Typically, instead, we're mostly going to focus on the guidance documents to the regulatory agency. And that concludes our video about guidance documents. I hope that this introduction will help you get your bearings for the cases that we're going to look at in this unit of our course.